The unfortunate reality is prosecutors often use the cost of a case as leverage to try to convince people to take plea deals. My name is Eric Purrier, and I'm the founder of Purrier Law. My firm is located in the Quad Cities, and we serve clients in Illinois and Iowa. I've been representing clients in criminal defense cases for about 15 years now. A couple of years ago, a USCCA member contacted my firm. Or I guess more correctly, I should say the USCCA Critical Response Team contacted my firm. The client was actually in custody. She was in jail on a $250,000 bond. She had unfortunately had to defend herself after she was violently attacked by a boyfriend's ex-girlfriend. The ex-girlfriend did not appreciate the new girlfriend, who was the client, and attacked her. She did great violence to the client. The client suffered significant injuries to her face. One of the things I remember the most was that the whites of her eyes had more red than white in them from the bleeding and the injury that she'd suffered while being violently attacked. Fortunately, that client was able to get to her gun, and she was able to shoot in self-defense, putting a stop to the violent attack that could have cost her her life or could have disfigured her permanently or caused all sorts of other harms. Unfortunately, the police saw it the wrong way. And that was due in part to how the client spoke to the police and due in part to just the stress of the situation. So despite the client's best efforts, she talked to the police initially, believing that because she had acted in self-defense, that there was nothing to worry about, that if she just told the truth, that it would all work out fine. Unfortunately, that's a common misperception that people have, and that misperception leads to people facing charges in so many cases where they have righteously defended themselves. Because she was out of jail, she was able to help me prepare her defense. We were able to convince the prosecutor to see it our way, and ultimately the charges were dismissed without her having to proceed through to trial. My client was able to go on with her life, not have any criminal conviction on her record, and lead a happy and healthy life after that. The unfortunate reality is prosecutors often use the cost of a case as leverage to try to convince people to take plea deals. In that particular case, we received multiple plea offers, starting with an offer to spend over 20 years in prison. And this is an offer being made to a person who has no criminal history, no felony conviction. She was a lawful gun owner who acted in self-defense after she suffered an unprovoked violent attack. When she received that first plea offer, it was a very scary thing for her. But she was able to know that she had us defending her, that there was no risk that she was going to run out of money to pay for her defense, that if we needed an expert witness, if the case proceeded to trial, we were going to have that expert coverage, that everything was being done to fight her case in a way that would let justice prevail. And so I think USCCA is something that definitely helped this client. It's helped other clients of mine. And for that reason, I'm quite a fan of USCCA.